carers into employment, education and training, and also just getting employment ready. So we are a London-wide project. There are 4 hubs. I'm from the Lewisham hub, and each hub covers between 8 and 9 boroughs. So we are the hub that covers Lambeth. But we support unpaid carers aged 25 and over to move, as I said, closer to employment. We are led by Carers Trust and the network partners across London. And we are funded by the European Social Fund and the National Lottery Community Fund. Our aim for our project is obviously the main goal is to support carers and former carers to move back into employment. And this is through confidence building, skills development, making sure that they have the right tools to move on. We want to do this in the most flexible way possible. We know that carers' lives are difficult and challenging, and even like post caring, the life is difficult and challenging, and we want to make sure that we are able to support each person that we are supporting in the way that's going to suit them. We aim to engage with local businesses and organisations to create employment, training and volunteering opportunities, and highlight the benefits of employing carers with employers and adopting carer-friendly policies. So this is kind of an overview of what we as a project would like to be seeing going forward. What we do in the day-to-day is that we offer one-to-one support and advice with dedicated employment advisors. We do group activities and training workshops. So we've been taking a more well-being approach in COVID-19, helping hosting workshops around well-being, resilience, but we also still do employment. We've got some up-and-coming ones around how to apply online and kind of getting a bit more tech savvy in that sense. So we try to meet the needs of what our carers, what our carers are fed back that they'd like to see. We also support with writing CVs, interview techniques, cover letters, job searching, and then access to employment, volunteering, and training opportunities. The eligibility criteria for our project, if you're interested, is to be an unpaid carer or former carer, aged 25 and over, living in London, and not in any paid work. As you can imagine, I have to say this for kind of any presentation, but we'll get to the more interesting stuff as we go along. So we found, and our carers have fed back to us, that the barriers that they faced to go into employment, some of them felt that there was an emotional barrier. There was a lot of guilt around if they were actively caring about leaving their cared for. If they've been a former carer, obviously there's the grief and the bereavement that they've had to deal with, which makes that kind of moving step forward. The need for flexible part-time or restricted hour working, it's difficult to find these roles, and there's a lot of concern about really needing the flexibility if my cared for is unwell, I need to go to the hospital, and there's kind of a bit of fear around that flexibility. Lack of self-confidence, social isolation, career gap, there's a big fear around that, how to explain that going forward, and will an employer understand that? Skills may be outdated. Usually IT is the main concern that we get raised and we try to address. Issues around replacement care, financial positions, if you want to retrain, financially maybe that's not a possibility right now. Own health issues, as we know, a lot of carers tend to have their own health issues. And again, fear of employer kind of understanding of the caring role. Routes to success, be honest, explain the gap. As you know, the amount of people who are caring for a loved one is increasing. There is a lot more employer understanding now than there was, say, 10 years ago. If you're honest about the gap, it's the gap. If you don't explain it, that's kind of what's going to make it difficult to get a role. If you can explain a gap, an employer is more likely just to go like, oh, okay, that's fine. It's a completely normal thing. People have gaps for various reasons. Subsidised training workshops, they are around, and our project isn't the only one that's offering it. Give yourself space to vent your concerns. This can be with a friend, it can be with an employment advisor. Just, often a lot of your concerns have a practical solution. So it's good to just kind of vent them out there, say them outside, and then maybe someone else can kind of give you the ideas that you need. Volunteering work experience, if you've been out of work for a while, is a good confidence booster and a good way to upskill. Private care, is it an option? If it's not an option, what can we do around that? Manage expectations around
flexible, part-time and restricted hour working. This will have improved with COVID. It's kind of proven that you can work from home and you can work from home effectively. So employers are going to be able to argue that less than they used to be able to. So I think there's going to be a great shift towards flexible working as employers also seek to, reduce office costs. It costs them a lot to keep an office up and running. So, if half the company works effectively at home and would rather be working from home, why have a big office? Is your identified job choice right way forward? If you are a person with quite bad back issues due to your caring role, is being a private carer the right move? It's only going to make it worse, and that's not something you want to be doing. The last thing you need is a slip disc. So it's just looking at the role and whether it's actually going to be the right fit for you longevity wise as well. Get support, whether that be from us or alternative. Like I said, we're able to help with this kind of movement forward, but there are alternative services that might be a better fit for you. But it's always good to get help. Why do it by yourself if you can have somebody who can help you go forward with that? Employment rights. So every employee who has been working with a company for 26 weeks has the right to make a flexible working request. So this can be informal, which can be done at any time, or a formal request, which can only be done once every 12 months. And the response needs to be confirmed within 3 months. There are 8 reasons to refuse a formal request, which I'll go through in my next slide. The important thing about this right is if you've gone into a role which initially started to work for you in your caring role, but that no longer is the case, there is a recourse for you to request changes to your contract and term of service. It might not be approved, but there is a recourse for you, and it's good for you to know that there is. So what kind of requests can be made? It can be for flexible, home working, job sharing, part-time, turn time, shift swapping, staggered hours, compressed hours, annualized hours. So it's a fundamental change to your hours that maybe would make the role easier for you going forward. You would need to make the request if this was a formal request. If it's an informal one, you can talk to your manager. I would say confirm in writing, especially if an agreement's been made. Always get that in writing so you have evidence that this has been, you've talked to your manager approved it. I would always write an email afterwards saying, lovely discussion, I've confirmed this, great to move forward with that. You always want that in writing, and you want them to confirm that they've, that meeting has taken place. But if you're doing a formal request, it needs to be in writing, it needs to be dated, state that an application has been made under the statutory procedure, so that you're invoking that, as it were. Specify that what change you want to see. So if you have been working Monday, Tuesday, and a Friday, but you want to change your Tuesday to a Wednesday, you need to state that that's what you're intending to do. You need to explain, and in detail, what effect it might have on the employer, what the solutions are, and why it actually won't affect the employer, you making that change. So an example being, I did have a carer call in who wanted advice around this, and they were upset that their formal request had been rejected. The reason that their formal request was rejected was that they wanted to change their shifts, which meant that only one person would be in the office. So for their health and safety procedures, because they were supporting people and people were coming into the office, it meant that it would not be safe for that one person. So that is a legitimate reason, and it's kind of a hard reason to argue against. Unless she was able to find someone who would be happy to switch their shifts around, so that they would be doing that morning shift so they could accompany it, they're not going to get that formal request approved. It has to be reasonable. It's not reasonable for the company to have one person working by themselves. That's a safety issue. So, you have to think about it in that sense. Is it reasonable what you're requesting? And would it actually have a negative effect? And if it does, what solution can you provide that means that it would not actually affect the company? So you do have to put some thought into it, especially if you really want it to happen, as it were. State whether you've made a application before to the employer, and if so, when. So if you've done it before but the situation has changed, maybe they've got more staff in, so maybe that safety issue is no longer an issue, state that you've asked it before, the reason why they declined it, and why you don't think that's an issue anymore. Does that make sense? So how an employer should deal with it, they need to deal with it in a reasonable manner. They need to give you a specific reason why it's not possible, and it needs to be, reasonable. Like, they can't just say, we think it will affect business, so no. They have to give a specific reason why they think it will affect business, and you then would have the right to appeal. So if you could find a solution to that, then you'd be able to appeal that and provide the solution. But they can't just reject it for no, there have to be a good reason for why they're rejecting it. They've got 3 months to get back to you, and if you are successful, it will probably be subject to a trial period and then will be made formal in your contract. Grounds for refusal are additional costs to the employer, negative effect on the ability to meet customer demand, inability to reorganize work amongst existing staff, inability to recruit additional staff, negative impact on quality, negative impact on performance, not enough workload during the periods the employee proposes to work, planned structural changes. So if you wanted to work mornings instead of afternoon, but hardly anyone comes in the mornings, then they could and have a legitimate reason for why they would review your request at that point, because there's just not the need for that amount of staff in the morning. What would happen next? Like I said, if granted, it's going to be a trial period. If it's successful, a permanent change. If unsuccessful, it's going to be refused, but you do have a right to appeal their decision. So if you find a good solution for it, you can appeal it. To take off it tends to be 1 to 2 days at any given time, and it's usually unpaid, but for some employers they will pay. So it depends on the employer whether or not they'll pay, or they'll say it's unpaid leave. So, it's good to look at their policies and how they would treat that sort of situation. But this is to deal with emergencies, and it has to be emergencies. It can't be planned in any way. So, and your dependents under time off for dependents counts as your spouse, civil partner, child, parent, or a person who lives in the same household. So time off can be taken for the following kind of reasons: to provide assistance if a dependent falls ill, gives birth, injured, or assaulted; to make care arrangements for the provision of a cared for who is dependent, is ill or injured, in consequence of a death of the dependent. This isn't formally compassionate leave. So a lot of companies do have compassionate leave, but that is something separate. But you could take some time off for dependents due to somebody passing away. To deal with unexpected disruption, termination, or breakdown of arrangements for the care of a dependent. To deal with unexpected incident which involves the employee's child during school hours. It doesn't apply to other events. So, if your house is on fire, it's not time off for dependents. Horrific, and hopefully your employer would be understanding that you'd need a couple of days off to deal with that. Probably more than a couple of days, let's face it, if your house is on fire. But it's not going to be covered under time for dependents. It's literally if there is an issue with your dependent that you need to be addressing. That is what comes under that. Okay, and again, doesn't apply to pre-planned arrangements. So this is only for emergencies. Reasonable time off. Again, as I mentioned before, there's no real fixed definition, so it will be up to your employer what they kind of term as reasonable, but generally it's a few hours or 1 to 2 days. But if your employer obviously agrees to more, great, but it will be kind of restricted in that sense. And it also depends on the nature of the incident and the individual circumstances. So like I said, it can be more than that, but it depends on your circumstances and whether or not your employer is happy to let you take more time off. But this is a right that's protected for you, so that essentially the government registers that things happen in life and you shouldn't be at threat of losing your job because something has happened. So you are protected to have this time off. Does that make sense? So the obligations, a right to time off only applies if the employee tells their employer, so you have to let them know the emergency as soon as possible and the reason, and how long that you expect to be away. So you have to let them know straight away, otherwise, it can be a bit more difficult. Parental leave, so if you are a parent carer, this is going to be relevant to you. The employee must have 1 year's continuous service and have a legal responsibility for a child aged under 18 years old. This can be birth parents, adoptive parents, or guardians. And you would be entitled to 18 weeks unpaid leave per child for the purpose of caring for that child. Blocks of a week can be taken off, and the contract of employment continues during leave. So they can't end the contract because you've taken this time off. The contract has to continue. But again, this is going to be based on the employer. So some employers may actually pay for this leave, and especially if it's an emergency, your child's had appendicitis, you obviously need to look after them for that week. It's something like that. They might be understanding and still pay you for that time. Does that make sense? But it's going to be up to the employer whether they make that paid leave or unpaid leave. Making a request. So hopefully you would have a bit of notice on some of these things. An employer may have a special scheme, as I said, but most take the default, which is you need to give a request 21 days notice. But obviously, if there's an emergency, there'll be some flexibility around that. An employer can postpone the request for up to 6 months, where it is considered that the operation of business would otherwise be unduly disrupted. So an example would be, usually you give quite advanced notice. So if your child has a hole in their eardrum, and they're going to have an operation to repair that, you'd usually get quite a fair amount of notice. It would be unreasonable for them to move the request at that point. So they do also have to be kind of reasonable. If there's an operation, it's not like you can move the operation to suit the employer's needs, but maybe you could find someone who could cover you during that time. When postponing the leave, the employer must consult and give new dates the employee is permitted to take within 7 days of request. So if they do have to postpone it, they have to give you dates which are going to replace that. Maximum of 4 weeks per year to be taken in respect of each individual child. Another thing is that carers are protected from discrimination, and this is from discrimination by association with someone who is protected. So the protected characteristics are age, disability, gender reassignment, marriage and civil partnership, pregnancy, race, religion or belief, gender and sexual orientation. Where somebody is treated unfairly because of one of these characteristics, then it's considered discrimination. And if a carer is treated unfairly because of their association with the person that they care for, this is considered discrimination by association. So there are different types, but those are the 2 types that we're going to be focusing on as they are most relevant. So disability discrimination is a physical or mental impairment which has substantial and long-term adverse effects on their ability to carry out normal day-to-day lives. And this is the legal definition, not the medical definition, and can be very specific. So when looking at discrimination, you need to look at the legal definition and whether or not you're cared for comes under that. So direct discrimination is that because of protected characteristics, A treats B less favorably than they would treat others. So, if you are disabled going into the workplace and, you tend to be a bit later because maybe it's a bit more difficult to navigate the office or, to get to the office than somebody who could just, easily walk through, then that's kind of seen as discrimination, and really they should be making changes to make that more accessible for you. So discrimination by association, this is where someone is treated less favorably because of their link or association with protected characteristics. An example is if an employee takes time off to care for their disabled mother, the employer disciplines them for doing so when they would not have disciplined others. So it's whether or not you are being unfairly treated specifically because of your carer status. At that point, you have action for recourse. So steps to consider are, check whether discrimination has taken place, you want to look at the legal definitions. Make an informal complaint first, then make a formal complaint and follow your company's grievance procedures. If that has not worked, then escalate it to an independent organization. So something along the lines of an ombudsman. So just as you would if you were having issues with a company, maybe getting a refund or they'd taken your money but hadn't provided the project, you would go to a financial ombudsman. You would do the same for discrimination. You'd want an independent organization to look at the situation and have that finding that they are indeed being discriminatively towards you, acting discriminatively towards you. That's wonderful English, as it were. Take legal action. Contact the ACAS, early conciliation, before bringing a claim to the employment tribunal. You can no longer go straight to the employment tribunal. You do have to go through the ACAS conciliation first. Essentially, employment tribunals were being overloaded by cases, and essentially, the Employment Tribunal wants to see cases with quite a severe and complex history. Most should be able to be resolved within the ACAS. So that's essentially why that's been put in place. Be mindful, you've got 3 months from the incident. Anything past that point is no longer actionable. So if you're having pretty bad treatment, you want to be able to take that forward within 3 months. Obviously, if you're getting new incidents, then that probably helps the situation for like a prolonged kind of case. But you want to be able to show that you were taking action from within 3 months of the incident. But of course, generally, you don't want to be going through those struggles. The important thing is finding the right role with the right employer. So check the terms of the role in the advertisement, find out more during the recruitment process, reach the employer, and are they a pro-employer, pro-care employer? Do they have policies? So for example, Lewisham Council have a policy that if you've worked for Lewisham Council for a set period of time, that you could have up to 3 months off due to caring role and caring responsibilities. So I would say that that is a carer-friendly employer. Obviously, it can be difficult. It can be a manager by manager basis, which is why you want to make sure that the policies reflect that it's carer supportive, that you've mentioned it in your cover letter, that you've mentioned it during the interview, that they're aware of the situation. And then if they employ you knowing that, then you've probably in a good place, you're with an employer that's going to be understanding, and that's kind of where you want to be. It's better to be an employer that's understanding than to keep the fact that you're a carer under wraps and then have difficulties later on. Communication during employment, as I said, say what your caring roles and responsibilities are and what they mean, and how in general it won't impact your work. But there may be instances, but you just want to be clear about that. There's no legal requirement to do so. You do not have to do this. It's just something that I recommend, and a lot of our carers have found that when they've been vocal about their caring role, that they have found an employer that suits them better. And you may find colleagues are supportive. You may find out that actually that employer has a group specifically for carers and or a forum. And other colleagues might be in a similar situation. So, it's just good to be vocal where you can, because, it's better to have support from those you're going to be working for than not. Yep, as I said, internal policies. Have a look at their internal policies. Are they carer friendly? Do they encourage flexible working? Is there enhanced time off for like emergencies? You want to be looking at those sort of things going forward. Just because you get offered a job, there's no reason why you should take it. Make sure that it's the right role for you and that it's going to work for you. Lovely. That's my end of my presentation, but I do want to point you to the fact that we have a series of fact sheets on the Carers Trust website, and they cover a range of subjects, including choosing the right jobs, interview trips. We have those on carers' rights and flexible working. We also more recently have one on wellbeing, and they will also link to alternative resources and organizations that, if you are having issues along these lines, might be able to help you. So just want to point you in that direction if you kind of needed a bit more information or wanted some resources elsewhere. Any questions?